Court-confirmed sales. What goes wrong and how I keep it clean. Court-confirmed probate sales are unlike any other type of real estate transaction. They require strict compliance with court rules, precise timelines, a public hearing, and legal oversight that cannot be ignored. Yet too often, agents treat them as if they were ordinary listings. That is exactly why so many court-confirmed sales go wrong. I have seen cases fall apart because buyers walked away at confirmation, listings contained the wrong legal language, or escrow timelines conflicted with court calendars. Attorneys end up scrambling to correct mistakes. Families become frustrated, and the case drags on much longer than it should. This does not have to happen. With the right process in place and a probate-trained real estate professional managing the property, court-confirmed sales can run smoothly from start to finish. Here's how I prevent the most common problems and keep these sensitive cases on track. Using the correct language in the listing. One of the most frequent mistakes agents make is failing to use the correct language in the multiple listing service, MLS. A court-confirmed probate sale cannot be presented the same way as a traditional listing. The terms must be made crystal clear to the public. This means disclosing upfront that the sale is subject to court confirmation, explaining the overbid process, and removing standard contingencies that do not apply. If this language is missing or incorrect, buyers and their agents are blindsided later in the process. They discover requirements they did not expect, panic, and walk away. I prevent this by ensuring that every listing is written with accuracy, compliance, and transparency from the start. The right disclosures are included, the overbid process is explained, and buyers know exactly what they are walking into. This small step eliminates major headaches later. Preparing the buyer and their agent from day one. Most buyers have never been through a court-confirmed probate sale. To them, it feels confusing and risky. They hear about confirmation hearings, overbid rules, and limited contingencies, and they do not understand how it all works. If no one explains it early, they often get cold feet and pull out during escrow. I solve this problem with a proactive intake system. From the moment a buyer expresses interest, I sit down with them and their agent to explain the process step by step. I answer questions, provide written outlines, and make sure they know exactly what to expect. By setting expectations early, buyers feel prepared and confident rather than overwhelmed. This keeps them engaged through the hearing, reduces fallout, and speeds up the overall process. Syncing the timeline with the attorney and the court. Another common mistake happens when agents build escrow timelines that do not match up with court calendars. This leads to unrealistic closing dates, missed filings, and unnecessary delays. I never make this error because I build my entire timeline around the court's schedule and the attorney's strategy. I do not pressure attorneys or conservators to move faster than the court allows. Instead, I structure the escrow process to flow naturally with the legal requirements. This alignment prevents conflicts, reduces stress for the attorney, and creates confidence for the conservator or executor. Everyone knows what to expect, and no one feels rushed or misled. Coordinating the overbid process and court appearance. The overbid process is another area where court-confirmed sales can fall apart. If buyers and agents do not understand how it works, they show up to court unprepared. I have seen buyers arrive without the required deposit check, without the right paperwork, or without knowing the bidding rules. When this happens, the court cannot approve the sale, and everything is delayed. I make sure that does not happen. I prepare a full sale summary, ensure the buyer has the correct deposit, provide clear overbid instructions, and coordinate everything needed for the court hearing. If necessary, I attend the hearing in person or work closely with the buyer's representative to confirm compliance. This preparation eliminates surprises. The court's process runs smoothly, the attorney looks professional, and the sale receives clean approval. Keeping the attorney informed without wasting time. Attorneys do not need to be buried under dozens of emails about minor real estate details. At the same time, they do need to know when major milestones are met. That is why I keep my updates clear, timely, and relevant. I notify the attorney when the listing goes live, when an offer is accepted, when the court hearing is scheduled, and when escrow is tracking properly. These updates provide confidence without unnecessary noise. Attorneys can focus on their legal work while knowing the property side is moving exactly as it should. Common mistakes that kill court-confirmed sales. To fully understand the importance of specialized management, it helps to look at the most common mistakes that derail these sales. Missing or incorrect disclosures. Buyers later discover requirements they were not told about. Unprepared buyers. They do not understand the court process, panic, and walk away. Escrow deadlines that clash with court calendars. This creates unrealistic pressure and disrupts filings. Lack of coordination for overbids. Buyers show up without the right funds or paperwork. Poor communication. Attorneys are left chasing information instead of focusing on legal work. These problems are avoidable when the right systems are in place. Why probate-trained agents make the difference. The truth is that most real estate agents are not trained for court-confirmed probate sales. They may be great at traditional transactions, but without experience in probate, they are likely to miss important details. A probate-trained agent knows what the court expects, understands the attorney's role, and communicates with heirs and buyers in a way that keeps everything aligned. This expertise reduces risk, saves time, and protects the integrity of the case. Real-world example. I recently managed a court-confirmed sale where the heirs were already frustrated. Their previous agent had listed the home without the right disclosures, and the first buyer pulled out days before the confirmation hearing. The attorney was left scrambling to explain the mistake. When I stepped in, I rewrote the listing with proper court language, educated new buyers and their agents on the process, and set a realistic escrow timeline. By the time we reached the confirmation hearing, everything was prepared. The court approved the sale without issue. The heirs were relieved, and the attorney did not have to manage any cleanup. This is the difference a probate-trained real estate professional can make. Court-confirmed sales are not regular transactions. They are structured, public, and legally sensitive. Mistakes on the real estate side create delays, increase stress, and leave attorneys handling problems that never should have happened. When I manage these sales, I ensure that every step is handled correctly. I use the right disclosures, prepare buyers, align with the court schedule, coordinate overbids, and keep attorneys informed without wasting their time. The result is simple: clean, compliant sales that move forward without drama. If you are handling a court-confirmed sale and want it managed properly from the beginning, I am ready to step in and take care of the entire real estate lane. Frequently asked questions. What makes a court-confirmed probate sale different from a regular sale? A court-confirmed probate sale requires court oversight, specific disclosures, a confirmation hearing, and a defined overbid process that does not apply to standard listings. Why do court-confirmed sales often fall apart? They often fail because agents use the wrong disclosures, set unrealistic timelines, or fail to prepare buyers for the process. This leads to confusion, fallout, and delays. How does a probate-trained real estate agent help attorneys? A probate-trained agent aligns the property side with the legal process, prevents mistakes, keeps buyers informed, and protects attorneys from being dragged into real estate issues. Let us keep your court-confirmed sale clean and compliant. If you are handling a court-confirmed sale and want it managed properly from the beginning, I am ready to step in and take care of the entire real estate lane. Simply scan the QR code to get started, or contact us today at 833-PROBATE. That's 776-2243. Visit 833probate.com or email info@833probate.com. Contact me today to take the entire real estate lane off your plate.